Welcome to today's webinar, Achieving DPDPA Compliance. This is the first webinar of the webinar series that we are doing on how we are going to achieve DPDPA compliance. Today, we are going to talk about consent management, and I'm thrilled to be here with you guys. We'll be diving into the world of consent management today. I'm Yogesh, your moderator, and we have two amazing speakers with us today, Himanshu and Supratim. So Himanshu is the CEO and co-founder at GoTrust, and Supratim is a partner at Khaitan and Co. So I'll hand over the stage to Himanshu and Supratim to give a brief introduction about themselves.
Thank you, Yogesh. Supratam?
Yeah, thank you so much. Hi, I'm Supratim Chakraborty. I'm partner in Khaitan and Company, one of the leading law firms of the country. And I've been working on the technology and data front for about 16 plus years, along with corporate M&A. Along with, have been very fortunate to have worked with some of the largest organizations in India and abroad. I've also been very happy to give assistance to the government in relation to some of the lawmaking that has happened around digital laws. Thank you.
Thank you, Supratam. Hello, everybody. This is Himanshu. I'm the CEO and founder of GoTrust. We have been building this tool for a long time to make sure that the compliances related to DPDPA are sorted. And today we're going to focus and talk more on the consent side. Of course, the tool covers all the aspects of DPDPA, but today we'll focus more on the consent. On the personal side, I've been working a lot, 16 years in the industry. We have developed multiple tools. And now this is one of the finest product which we have produced for the Indian market, and it's designed and developed for the Indian market from the scratch. So I hope today's webinar will be knowledgeable and will help you to comply with the consent laws which are coming according to the DPDPA. Back to Yogesh. Thank you.
Thank you so much, guys. Let's start this conversation, I think. And I think the first and the most talked about point right now in the industry is like in the current data privacy law parlance in India, what is the difference between the current consent regime, like that we are following in the Indian ecosystem, versus how it will be molded or changed after we start adhering to the DPDPA Act, or the DPDPA Act comes into full force or full form? So I think we can hear a bit about that from Supratim first.
Yeah, thank you so much for that question. Very important one in the given times that we are living. So let's understand on a sector neutral basis, what do we have as a law on data privacy and protection? Largely a couple of sections from the Information Technology Act. Okay, there's one section which is section 72A, which is dealing with only personal data. Okay, and what it says largely is that if you are disclosing personal information against consent having been taken, or a contract that you have with an individual, then there could be certain penalty. Okay, it has been decriminalized, by the way, and I'll talk about the penalties later. But in this context, only when we are dealing with only personal information, it there is a requirement to take consent in the parlance that I talked about, but there is no parameter which is given how that consent has to be taken. Okay, it's pretty fluid, so you can take consent in any form, and you know how it happens, right? It is sort of hidden somewhere in your privacy policy, terms of use, etc., etc. So that's one part. The second section is section 43A, which is dealing with sensitive personal information, along with a set of rules, which is called the sensitive personal data rules. Mostly it is referred to as SPDI rules. Okay. Now, when you look at SPDI rules, it does go into some bit of granularity when they're talking about consent. And they have thankfully said that consent to be in writing. And by in writing, it also kind of means that it can be taken in any mode of any electronic mode. You can take that consent. It also states that when that consent is being taken, certain things should be kind of known to the person who's giving the consent. And what are those things? That's basically the fact that the consent is being taken, the purpose for which the consent is being taken, the intended recipients of that consent, and the name and address of the agency that is collecting the information, and the one that would be retaining it. But all of this comes with a bit of a catch, which says that this should be taken by the body corporate, and they should make reasonable sort of takes reasonable steps. So in the given circumstance, so it somewhere puts on an obligation, but it also kind of makes it a little, um, I would say, light touch, or something that is in the hands of the body corporate to really justify that in the given circumstance, was I able to convey all of these to the individual from whom I am taking consent. Now, we are now moving on or planning to move on to a completely different platinum standard, I would say, which is what has been mentioned in the Digital Personal Data Protection Act. And if you read the act, there are a lot of words which are used when they're talking about consent. Consent should be free, specific, informed, unconditional, unambiguous, with clear affirmative action, etc., etc. So I think, again, a quantum leap for a country like India, which, like I mentioned, that which probably hardly had anything as a proper guardrail when you think about consent, to something which is more international standard, platinum standard as far as consent is concerned. I'll pause there. Very happy to hear from Himanshu.
I think that was really great insights, like in terms of understanding the law. I think Himanshu can add on a bit more about how companies are perceiving it.
Sure, definitely, definitely. See, what you just heard is the legal and the compliance,
Right.
from the legal point of view. Now, my role in this webinar is to help how easy we can make it. This challenging the platinum standards, how we can make sure it's implemented with ease, with ease, and also not just ease, but also implement very fast. Because as soon as the rules are out, these things will become mandatory, and then you will not have a lot of the businesses will not have too much time. Of course, some time is there, but not, let's say, not years to implement something. So technologically, IT is very challenging. So therefore, our product, which helps the customers in the way that they can opt in. Consents can be implemented, with multiple ways. Can be API based, where we can collect the consent from their system. We can give the forms, which is designed in the look and feel of the customer, or we can also give our own forms, which are designed and deployed on the customer's website, or the portal where the consent has to be taken. So we are helping customers by understanding. So today, all these forms are available in English, but we are also making sure that it's available in multilingual, because as per the law, I think I can add one more thing. It also needs to be available in multiple languages, right? So,
Oh, yes, absolutely. Yes.
okay, so that's what we are doing basically to help the customer base across India, and also the learning is coming out of GDPR, because we have seen a lot of companies. We have seen a lot of companies in Europe, in India, how the consents were mandatory and how the consent were implemented across the companies within Europe. So those learnings are also in the tool. Basically, that's how we are helping the customers. Yogesh, back to you.
Thank you guys for these insights. And I think people have, like, after hearing this discussion, have understand half of the law, like what is the law that we need to adhere to. Now let's moving on to the part if we don't adhere to it. Like in a case scenario where, let's say, we as a company fail to comply with this, what are the penalties or what are the legalities that will follow us? Let's take this conversation there now to complete it. Yeah. I think
Right. I
Supratim.
think, yeah. No, I think a good question to make this discussion complete, actually. The first part of the question, we deep dived and talked about what is there today and what we are looking forward to. Let us also then compare the penalty provisions that are there. So the first provision that I talked about, which is Section 72A of the Information Technology Act, which talks about handling personal data in a service scenario, so to say. Um, it has been decriminalized, like I mentioned, and the penalty right now is Indian rupee 25 lakh. Okay, up to that amount. Now you can understand that if someone is kind of carrying out an activity which is not kosher with the law, and they're a large player, this will hardly make a dent, probably. Um, let's talk about the second section, which is Section 43A and the sensitive personal data rules, which is dealing with sensitive personal information. There, damages can be claimed by way of compensation. Okay, when you look at the trajectory of the case laws that have happened, it ranged from somewhere from say a few thousand rupees up to a few lakhs, where it has reached till now. Okay, it's not that We have seen a lot of exemplary punishments being given, a humongous number amount being slapped as a penalty, so that it can set an example or a deterrent value for really people, so that they follow it. On the other hand, when you look at the Digital Personal Data Protection Act, we are all aware that penalties can go up to rupees 250 crore or more. In the context of consent, probably it could uh, be linked to the penalty line item, which is around 50 crore. But again, depends on what additionally goes wrong along with that. You could trigger one or more of the penalty provisions that are there, which again, like I mentioned, can go up to rupees 250 crore, which is the highest bucket. And therefore, probably people would be more serious about it going forward. So that's my 2 cents.
Himanshu, anything from your
Thank.
side?
Yeah. So, well, like I said, in Indian laws, Indian government has put the certain uh, cap on this part. So, I would like to ask a question. It's possible that there are multiple flaws that you are processing data in India, and without having a consent of, uh, let's say, a principal who is not an Indian. So, is there possibility that you have multiple laws are applicable and you pay multiple fines in different geographies? That's also is possible.
Yeah, so interestingly, almost every jurisdiction either has a law on data privacy and protection, or they are in the process of making one. Okay, most of the cases where we see a data protection issue, or say a cyber breach issue, or incident where personal data is involved, it is multi-jurisdictional in nature, and that time we need to dissect and see, okay, what were the parameters under which the data was collected, etc., etc., right? So I'm sure that different jurisdictions would have different legal consequences if you have not followed consent, or whatever is the ground, the legal ground of processing that would be there. Mind you, consent is one of the critical grounds, of course, and India is very consent heavy, so to say, when you look at our law. So depending on what happens in a particular situation, you'll have to see either you had consent, or you've been utilizing one of the other rounds of processing the personal data.
Thank you. I would also like to ask some questions to the attendees. If there are any, please, you have a comment section, please ask so that we can be more relevant towards you. Any doubt, any questions, any knowledge you need to know, please ask so we can make this webinar more, connected to you guys and more for you. Rather, we just give our information and details how we have designed the system. Okay. Then back to Yogesh. Thank you for Supritam for the information, how its multi-geography is applicable and risk can be basically at multiple levels. Yeah, Yogesh, back to you.
Thank you guys. Thank you guys for helping us understand what are the penalties. And what I can see is it's almost a 2000x increase in the kind of fines that they have to pay at the end of the day. So, as an organization who have to follow like consent, like acquiring the right consent to process the right kind of data. So, I'm sure you guys have observed like the common pitfalls, like the common mistakes that the companies do while trying to comply to this law, because it's something new right now and people would want to learn from like the previous mistakes or the previous problems that you guys have seen across the world, across different geographies. So I would love to know a bit more about that to take this conversation into a better direction.
Yeah, I think Himanshu can also chime in here and speak from his experience. But I would say the most important one here would be for organizations to know where is the data. When you get these requests from data subjects, most of the times people are quite clueless that where all does this data reside. We have had instances under the GDPR regime where, say, a person would have said, please do not send me marketing mails. And even thereafter, the person has again received another marketing mail, and then everything flared up. It went beyond proportion, and we were firefighting for several weeks to see that we set our house right, etc. So I think if you ask me, if I have to pick up one which could be numero uno, I think this would be one. But again, Himanshu, very happy to hear from your experience as well.
The example you gave, this is first thing when you go to the counter to buy something in India, they ask, "What's your phone number?" Bill dena hai ispe, bhi number pe bill aayega. Will that stop? Because that's the most scary thing I find. They give my phone number to get the bill, because why can't they print now? So that's one thing. And see, that's one thing how still the Indian businesses are behaving. Maybe the laws implemented will change. See, I can also add on experience in Europe when I'm there buying, doing shopping, anything. So when you say there are multiple type of consents we take from end customer, whether it's in-house product or not in-house product, doesn't matter. There's a marketing consent, there is general terms and condition consent, and so on and so forth. Now if you see the detailed level of consent management tools are providing you, multi-level of consents within the application, so you can see marketing, cookie, and all of that. So but that also is implemented, and this is not that it's a magic that's implemented. There is a tool, there is a technology which supporting it. And there comes the learning which we have, at least on GoTrust, that we learned how GDPR was implemented, how the consent there, which is not that complex as compared to DPDPA, was implemented, and how it is going beyond uh, basically. So the technology is the key to make sure that we can implement such a solution into any businesses. Basically, of course, not all of them will adhere to it on the same day, but yeah, step by step they will, and they have to once the law becomes more stringent. That's I would like to say basically how technology is going to help. Yeah, Yogesh.
Great, great. It's like this conversation is helping me understand a lot of things right now, like how the direction should be and what are the major pitfalls. But meanwhile, before moving forward in our conversation, there are a couple of questions that we can address, I think. So, first of all, we have a question from Yashu here. So, she's asking, how can a in-house counsel ensure at the first stage to implement the DPDPA Act in an organization?
Right. I think maybe I'll take a crack, and Manchu, please feel free to also again chime in. Because the question is also from an in-house counsel perspective. Maybe let me give a lawyer's perspective first, right? What we have observed across all jurisdictions, that you can broadly break this up into bite-sized pieces, okay, for the organization to digest this huge law, the magnanimous law that you have in front of you. The first one is and the phase one, I would say, is the training and sensitization, okay, because it will never be a success in your organization unless every person, till the last person on the floor, is educated well in this law. But again, one size does not fit all. Remember that. Okay. Largely, you would have two to three categories of training that you would require. The first one is for the top management, okay, which can be a 45 minutes to 1 hour session because their time would be more valuable, attention span would be less, etc. Where what do? You take the buy-in largely because within the organization they will have to bless that going forward, people would have to double hat, triple hat. They will have to spare times separately, for the privacy related exercise that you would be doing. So unless you have this buy-in from the top, it could be very difficult. So that is your phase one, type one that you have to clear. Next would be mid management training, which could be 1 to 2 hours, and these are the people who would be overseeing the project. Okay, and then the last one is for maybe it can be a workshop actually, which is a half day or a day long workshop for the people who will be dotting the I's and crossing the T's. This can be the privacy champions in each of your functions, whether it is HR, marketing, legal, IT. You can have, because you alone cannot see this through, you will need support from all these people. Okay, so we finish phase one this way, with these three categories. Three, at least you should have two categories. If you have three, great. So this training and sensitization is the first leg, uh, which does not need the rules to come out, by the way. Okay, so you should start this and try and conclude this as soon as possible, but try and make these more curated to these people. Don't try to give a very high level generic sensitization because that time is gone. It is more action time, so you should give them examples. You should try and have simulation exercises, gamify things, etc. Okay, so that's first. Then comes phase two, which is the gap analysis. where am I today and where do I need to reach? Again, probably you will not need the rules for this, which many people are waiting. Okay. To know what you have been doing in your organization as far as data privacy and protection is concerned, you do not need to see the rules. So you can get started with this particular phase as well. So this is phase two. Then comes phase three, where you will have plugging of the gaps. Okay. And then you can also have tools like Manchu was mentioning, which kind of makes your life easier. Because at a future date, when you get a request from a data subject or data principal, as it is called under the DPDP Act, you should not be running from pillar to post to understand that, okay, where does this guy's data lie? And if I have to really ensure that the request is attended to within the timeline, probably which will be called out under the rules, and is not repeated against his wish, like that example I was giving. Someone said, please don't send me marketing mail. Imagine that guy getting another marketing mail, right? You will have mayhem in your organization. So, depending on the size of the organization, probably it will be advisable that you have appropriate tools also incorporated. Over to you, Manju.
I think you have answered perfectly. And looking at the time, and there are two more questions in the stream. So Yogesh, if better you put the other questions and we can move on.
Sure.
Yeah.
Uh, Thanks, Supratim, for answering it very thoroughly. I hope, Yashu, your question is answered properly and thoroughly by Supratim. And I think the next question is asked by Saurabh. Saurabh is asking how significant data categorized according to DPDPA.
Right. So, we are all aware that this is a very unique feature of this particular law. And it is trying to create two types of data controllers. Okay, controllers as it is known in the international parlance and under several laws, including, say, GDPR. One is a normal fiduciary who will have to follow whatever is written in the law, and then you have significant data fiduciaries who will have some additional obligations, like having a data protection officer in India, carrying out data protection impact assessment, and also having an independent data auditor, so on and so forth. Now, this the act itself does not really call out who all are supposed to be significant data fiduciaries, but they give certain guardrails. If you're crunching enough amount of data, or there'll be impact on the security of the state, etc., etc. Interestingly, just to tell you, right after the app came out, we all got to know that some of the significant social media platforms were huddled by the ministry, and they were spoken to in relation to this law. So everyone thought that probably this is a good example of a significant data fiduciary. Probably they are being told beforehand, right? But right now, in the absence of the rules and any further notification, there is no certainty as to who all would be categorized as significant data fiduciaries. The broad parameters, of course, have been provided. We'll have to wait and watch on this.
Correct.
And thank you so much, Supratim. Himanshu, do you want to add anything to this answer?
No, I think it's perfect. So there's that's how it is. So there's yeah.
Thanks, Saurabh, for asking the question, and thank you so much, Supratim, for answering it so aptly. So I think we have understood a lot about DPDPA by now, like how the law is going to change our approach toward consent and what are the penalties around it, what are the common pitfalls that we're going to should avoid as an organization. Now, I would like to know from Himanshu's end that how GoTrust is solving these problems, how GoTrust is helping organizations to demystify the consent framework of DPDPA.
So
Over
I
to you,
think
Himanshu.
looking at the time, we also need to wrap it up. So I will do a quick, you know, info info session now. So we have basically two modules within the tool. One is UCM, we call it. That's Universal Consent Management. Another one is Cookie Consent Management. So these two helps us to deploy it at customers, and a customer's location, website, and or on-prem or cloud deployment. It will happen, and then based on these two, we'll collect the consents. Whether it is a quick consent, then we know precisely whether what kind of information we collect from the customer or not. And when it is at the when we're talking about the universal consent management, then we precisely know what are the preferences of the customer are there in relation to its whether we can send a market email or not. Those kind of preferences we collect. So there are two different ways when we talk about consent. What we're trying to do. Then within consent management, we have multiple flavors. Basically, number one is you can have the forms, you can have web forms, you can design the web forms, you can configure the web forms according to your own look and feel. Then Other way around is the APIs, because if you have your own web forms and you already have consent, some kind of consent already collected in the past, so we can also get the history data, migrate it so that we have one place where we have all the consent. So central storage, basically, of all the consents, that is taken care of. And then the last one is the API based consent. So in case you have mobile app or a website where you already have certain ways to collect the consent, we can give our APIs to expose, and then also the consent is taken in that form. So this allows an end customer to seamlessly integrate with our tool without disrupting their any existing processes. So we just don't want to interrupt in their process. We just sit and listen, and that's what the consent does. We listen, and then we give answer whenever is asked. Okay, if Supritam is asking for a services, then we already know what kind of services he has signed in for from the consent point of view. And if we want to send new services to Supritam or to you, Yogesh, then we must be sure that okay, in the tool, technologically we are aware that okay, what is allowed, what is not allowed, what the preferences of end customers are, and based on that, basically the customer is going to decide what kind of information is being pushed towards end customer. So we will sit, we'll listen, and we'll only help the customer to make the right decisions from the consent point of view. That's how the consent is designed, basically.
Got it. Got it. Thank you so much, Himanshu, for elaborating that. And I think after you answered this, a couple of our viewers must have the curiosity to know how easy it is to implement the universal consent management module of GoTrust. Like, will it take lifetime to deploy, or will it happen in a second? How it's going to happen?
Now, so normally, when we talk about it, is a week time when customers onboarded with a standard solution. So that's including the modifications and deployment of the solution with look and feel, the color, the forms, everything. So 1 week is a standard timeline where the customer can start with our tool, and they can directly sign up from the website also. So that's how the process is. That's a simplification which we have built in, and what we learned in Europe across implementing GDPR. So those are the learnings which we brought in for the Indian market.
Great, great. Thank you so much, Himanshu, for helping us understand about GoTrust as well. I think we have one last question. Vishal here posed, for larger organization, is it necessary to take express consent, or we can rely on deemed consent as well for implementation? Let's say benefits to employees.
Okay, I think this one, the question is a bit complex. So, firstly, to just break it down into small pieces, there is no leeway which you separately get just because you are a larger organization. But there are two buckets. One is consent, and then there are other grounds of processing. Just to simplify, for everyone here. For example, medical emergency, right? We all saw Munna Bhai and we say that koi mar raha hai, to does that person need to sign a form? Answer is no, because you have another ground of processing, which is medical emergency. Similarly, there is another ground of processing which is called the employer-employee relationship. Okay, so for the purposes of employment, if you are doing certain things, then you need not take consent because you are getting the umbrella, the premise of that particular other ground of processing. Okay, but just make sure that this is squarely within the premise of an employer-employee relationship. Sometimes certain things could be a little off. For example, say a family day or whatever, where the entire family of the employee has come and you take their kid's name and detail, etc. Please, it would still be advisable to take some consent for those things, because India has always been a very consent heavy regime. Okay, so when we are moving to that regime, pure employer-employee relationship, I think you can kind of rely on that new ground of employer-employee relationship. But beyond that, beyond the other grounds of processing, it would be consent, which would be relevant.
So, Pritam, if I may ask, say, if you read the first part of the question where it says for larger organization, it is necessary to take express consent, or we can rely. I think in any case, consent is needed, right? That's the first basic.
Yeah,
Right?
so like I mentioned, that see, this law now brings in additional grounds of processing. Okay, um, employer-employee relationship is such a ground, but it has to be looked at very carefully. The reason I just stated one of these things is that there could be certain things which is a little beyond the core relationship. Second is that minus the DPDP Act, there are many other employment and labor laws which are there in play. So someone asked me a question: should I stop getting a employment letter signed by the employee? Answer is no. Please don't do that. It could be catastrophic, because there are certain other contractual and other employment and labor laws which are in play, which kind of requires that you have such a sign off from the individual. why did we have this special ground? I would say, and this is a debate which we had with Justice Sri Krishna when he was crafting the first version of the law. If you look at the employee investigation today, internal employee investigation, and you read sensitive personal data rules under the Information Technology Act, the one that I was talking about, very literal legis, like reading the law in its true sense, in the black letter of law, the way it is written, you would see that it is stating that you have to take consent from that employee if you are looking into the system where the person has stored sensitive personal data.
Mm.
So unless you've taken some kind of consent from that employee at a particular date, in a bad day, you'll have to actually say that, listen, I want to look into your laptop where you've saved sensitive personal data. Please give me a sign off so that I can look into the laptop. Which was becoming ridiculous, because of course in a bad day when you're not seeing eye to eye with that disgruntled employee or a rogue employee, the person would not give consent. So therefore we needed another ground of processing, and employer employee relationship came handy as that ground of processing, where it says that for purposes of employment or for protecting the employer, such as against corporate espionage or protecting IP of the employer, etc., etc.
Nice. Thank you.
Great. Thank you. Thank you so much, Vishal, for asking the question, and I hope your question is answered in detail. And thank you, Supratim, for your time. Thank you, Himanshu. I think we would be able to end this discussion today on this high note. Like I personally understood a lot about the law today from Supratim, from Himanshu, and was able to create a vision that how it can be implemented in the organization from one law perspective, second from the business perspective. So that's a great discussion. Thank you so much, guys.
Thank you, Yogesh, for helping us know the structure. Uh, there are a few more questions which has not been answered. I see them in the chat, but definitely we'll get back to you with all our knowledge to give answer to those questions. Thank you, Yogesh, and thank you everybody for listening to us. And this is a series, like Yogesh mentioned. We're gonna uh, uh, dice and slice DPDPA, and we'll pick up the important aspects like consent and so on and so forth. And we'll be back weekly, bi-weekly with you to discuss more on these topics. And thank you for the interesting questions. So, Pratim sir,
No, thank you so much, everyone. It's a pleasure to be speaking with you guys, and to be amongst all of you. Thanks.
thank you.
Thank you.
Thank you,
Thank
everyone.
you.
Thank you.